A prosecutor can change lives with a subpoena, with a signature, with the weight of the state behind him. But what if that prosecutor has no legal authority at all? This week, a federal judge delivered a stunning answer. She ruled that a Trump-appointed acting U.S. attorney was serving unlawfully. Every investigation he launched, every subpoena he signed, possibly void. The target was Letitia James, New York's Attorney General, one of Donald Trump's most determined political adversaries. This was not about innocence or guilt. The judge was clear. Power exercised without lawful authority is not power. It is abuse. When the executive branch bypasses Congress and then turns prosecutors against political opponents, the system itself is at risk. If you care about how democracies actually fail, quietly, procedurally, legally, stay with me. Because this case is not an exception. It is part of a pattern, and to understand that pattern, we need to look at how the rules were bent in the first place. Let's slow this down and define the problem clearly. At the center of this case is a simple question. Who is allowed to wield prosecutorial power in the United States? The law is explicit. U.S. attorneys must be confirmed by the Senate, or temporarily appointed through a narrow process defined by Congress. Those limits exist for a reason. They prevent one branch of government from concentrating power. They ensure prosecutors answer to institutions, not individuals. But in recent years, that boundary has been tested. Again and again, instead of seeking confirmation, the administration relied on titles: acting, interim, special attorney, different names. Same result, prosecutors exercising enormous authority without democratic approval and without judicial consent. In this case, that authority was directed at a political rival, not through speeches, not through elections, but through criminal investigation. That is what makes this moment so dangerous. Because when legal procedures become political weapons, the damage does not end with one case. It reshapes the system itself. And to see how that happened, we need to look at the legal architecture that was quietly bypassed. To understand how this became possible, we have to go backward, not to personalities, not to politics, but to structure. For decades, the appointment of U.S. attorneys followed a predictable cycle. The president nominates, the Senate confirms, checks and balances do their quiet work. When vacancies appear, the law allows short-term fixes, strictly limited, clearly defined, temporary by design. These rules were written after abuse, after moments when presidents tried to bend prosecutors to their will. Congress responded with guardrails. But guardrails only work if they are respected. In recent years, those limits began to blur. Temporary appointments stretched longer. Titles multiplied. Legal gray zones became operational strategy. The justification was efficiency, speed, continuity, but the effect was something else. Power moved away from institutions and closer to the executive. And once that shift happens, the cycle accelerates because every workaround becomes precedent. Every exception becomes normal. By the time this investigation began, the system was already strained. And that strain was about to produce its first real rupture, which brings us to the moment everything came into the open. The rupture did not come quietly. It arrived with subpoenas. In August, 2 grand jury subpoenas were sent to the New York Attorney General's office. They demanded records, internal communications, details of investigations that Letitia James had led against Donald Trump and the NRA. On paper, this looked routine. Prosecutors investigate, grand juries ask questions. But beneath the surface, something was wrong. The man signing those subpoenas was John Sarcone, an acting U.S. attorney, never confirmed by the Senate, installed after his temporary term had already expired. This was not a technical error. It was a deliberate workaround. And this time, the court noticed Judge Lorna Schofield stepped in. Her language was blunt, unusual, unmistakable. Sarcone, she wrote, was not lawfully serving. His authority did not exist, and actions taken without authority are void. If this kind of detail feels abstract, pause here. These technical moments are where power quietly changes hands, because once subpoenas become tools of retaliation, the line between law enforcement and political force collapses. And that collapse exposes the machinery beneath the system. What Judge Schofield exposed was not just a bad appointment. It was a mechanism, a way of concentrating power without ever announcing it. Here is how it works. Congress sets limits on who can become a U.S. attorney. Time limits, confirmation requirements, judicial backstops, those limits slow things down, and slowing power is the point. But there is a workaround. An attorney is appointed temporarily. When the clock runs out, instead of stepping aside, the title changes. Special attorney. First, assistant. Then quietly, acting U.S. attorney. No Senate vote, no judicial appointment, just continuity of power. On paper, each step looks technical, defensible, boring. In reality, the effect is profound. A prosecutor answers upward, not outward. To the executive branch, not to Congress. To political priorities, not institutional norms. And once that structure is in place, it can be aimed at investigations, at subpoenas, at political opponents. This is why courts matter so much here. Because without judicial intervention, this mechanism does not self-correct. It expands. And when it expands, the next crisis is never far behind. Which brings us to what happened next. The second crisis did not unfold in New York. It happened hundreds of miles away, and it revealed that this was not an isolated incident. Last fall, a federal grand jury in Virginia indicted Letitia James. The charge was narrow, a mortgage application from years ago, an alleged misstatement to secure a slightly better interest rate. On its face, it sounded technical, almost mundane, but the pattern was familiar. The prosecutor who brought the case was also an interim appointee, selected by the Trump administration, never lawfully confirmed. Once again, the courts intervened. A judge ruled that this prosecutor, too, lacked valid authority. The indictment collapsed, the case was dismissed, and when prosecutors tried to revive it, they failed. This moment matters more than it seems. Two different states, two different prosecutors, same legal flaw, same judicial outcome. This was no longer coincidence. It was evidence of a strategy repeatedly running into the same constitutional wall. And that wall exists for a reason, because when criminal law becomes a political instrument, it does not need to succeed to intimidate. The damage is done simply by being deployed. And that damage does not stop with the target. It spreads outward, which brings us to the people who feel it most. Now, let's talk about you. Because when institutions bend at the top, the pressure never stays there. It moves downward. You may never face a grand jury. You may never receive a subpoena. But you live inside the consequences of a system that others are willing to weaponize. When prosecutors appear political, trust collapses. You stop believing investigations are neutral. You start wondering who is next and whether the law protects you or merely watches you. This uncertainty is corrosive. It changes behavior. People self-censor. Institutions hesitate. Officials think twice before enforcing rules against the powerful. And over time, something deeper breaks. The law stops feeling like a shield. It starts to feel like a threat. If you've ever asked why democracies feel more fragile, more tense, more anxious than before, this is part of the answer. Because democracy is not just elections. It is confidence. And once that confidence erodes, it is painfully hard to restore. If this resonates with you, share it, talk about it, because silence is how systems decay. And what happens next does not stay local. It goes global. What happened in New York did not stay in New York. Because when the rule of law wobbles in the United States, the signal travels. Allies are watching. Rivals are learning. America has long claimed moral authority, not because it is perfect, but because its institutions correct themselves. Courts restrain executives. Law constrains power. When that balance falters, the message changes. Authoritarian leaders point and say, "You do it too." They use American precedents to justify their own abuses. Selective prosecutions, politicized courts, legal retaliation dressed as procedure. At the same time, democracies that rely on U.S. credibility feel exposed. If institutions can be bent in Washington, why trust guarantees elsewhere? This is how influence erodes, not through defeat, through imitation. And the danger is cumulative. Each legal shortcut becomes an example. Each unchecked maneuver lowers the global standard. What begins as a domestic fight slowly reshapes international norms. And once those norms slip, they are rarely restored, which leaves us with the hardest question of all: where does this go from here? Looking forward, there are only a few ways this can unfold. The first is the optimistic path. Courts continue to intervene. Appointments are enforced strictly. The executive branch is pushed back into constitutional lanes. In this scenario, the system bends but does not break. Judicial rulings become deterrents. Future administrations think twice before testing the same boundaries. The second path is murkier. Courts intervene inconsistently. Some appointments are blocked, others slip through. The rules remain on the books, but enforcement depends on timing, judges, and political will. The result is drift. Power expands quietly. Norms weaken slowly. No single crisis feels decisive until suddenly it is. Then there is the darkest path. Legal workarounds become normalized. Acting prosecutors become permanent fixtures. Confirmation becomes optional in practice. In this world, criminal law is no longer neutral. It becomes strategic. Opponents are investigated, allies are protected. And legality becomes a matter of interpretation, not principle. History tells us something important here. Democracies rarely collapse dramatically. They hollow out. And the future depends on whether institutions are defended when the violations still seem technical. Because once they feel normal, it is already too late. Which brings us to the final question. We end where we began, with authority, not the loud kind, not the theatrical kind, but the quiet authority that comes from legitimacy. What this case ultimately shows is not that the system failed, it's that it was tested, and for now, it held. A judge stepped in. Rules were enforced. Power was told no. That matters more than any single name in this story. Because the real question is not whether Trump overreached or whether Letitia James was targeted. The real question is whether future leaders will learn the right lesson. That procedure matters. That legality is not optional. That power without restraint corrodes everything it touches. Democracy does not survive on good intentions. It survives on boring rules, followed consistently, especially when it is inconvenient. If you found this analysis useful, stay with this channel. Share it with someone who still believes institutions protect themselves automatically. They don't. They survive because people notice, because courts act, and because citizens care before it's too late. This story isn't over, and the next test is already coming.